Hi, thank you very much for joining me here today. My name is Bruce Abramson, and the title of this talk is Winning the Aftermarket. Now, this talk is a part of a series that I'm putting together. The rough theme of the series is strategy in an era of strong intellectual property rights. For those of you watching this streaming live, this is the first in the series. For those of you who are watching it recorded long after the fact, the talks are designed to be viewed in whatever order you want. But with that said, let me plunge ahead into the topic of today's talk, winning the aftermarket. Now, it turns out that the best way to win anything is to avoid losing. So I'm going to start with a cautionary tale, or don't let this happen to you. Facebook, you might have heard of it, big company, less than 10 years old. They developed a powerful platform for social interaction. Okay? Everybody joined Facebook. Facebook runs the best party in town. We all want to be there. Another company you may have heard of, Zynga, developed some popular social games running on the Facebook platform. Zynga really turned out to be a pioneer in social gaming. They were the ones who mastered the use of Facebook and social media in general for shared games, became hugely popular very fast. Certainly in the early days, and probably still, they were the single most successful app developer on Facebook. What happened? Well, Zynga, let's go back to Zynga. Zynga came up with a great way to make money, right? Turns out that social networking, as many of us have seen, not clear how you make money from it. How did Zynga make money? They got a whole bunch of people sitting on Facebook using their apps, playing their games, became very popular, and they came up with a great idea. They decided that they would sell credits. What do game credits do? Well, if like me, you're not a gamer, you might need a little bit of an introduction. But basically, games, multiplayer online games, all become more interesting as you move on to higher levels. Problem is you have to start out at the low levels, and periodically when you get killed, you go back to the low levels. My understanding is not too many people get killed in Farmville, but you never know. So what game credits do is they let you skip. They let you skip some of the boring stuff and move forward. Sometimes they let you buy things that help you succeed. But they are useful mechanisms for enhancing the pleasure that gamers get out of the games. So Zynga came up with this idea that the way that they would convert all these active gamers into money was they would sell them credits that would enhance the experience. And they did. And they became hugely successful. They generated a tremendous amount of revenue very, very quickly. And they started talking about it. They were very eager to go public. What happened next? Well, Facebook, remember Facebook? They came around and they said, hey, we think it's great that you've invited all of our friends in our party to play your games, because that makes our friends happy. And we think it's great that you figured out a way to generate some revenue from this, because quite frankly, at the moment, this was several years ago, we're not generating much revenue on our own. So here's the deal. From now on, you give us 30% of everything you make selling credits, because we have a rule that says that anybody who sells credits on Facebook has to sell Facebook credits, and we take a 30% commission. And Zynga said, go to hell. And they held a bunch of dueling press conferences, and Zynga said, there's no way we're caving on this. You can't take almost a third of our revenue. We will get off Facebook. We don't need your platform. And Facebook said, well, have a good time, guys. I'm sure all your gamers will follow you. Knock yourselves out. And Zynga held more press conferences, and they insisted they wouldn't do it. And the day of reckoning came, and well, if we fast forward ahead by a year or so, when Facebook finally did go public and released its numbers prior to its IPO, Zynga was responsible for between 11 and 12% of Facebook's total revenue. Zynga caved, which brings us to the situation today, which is that Zynga now sells Facebook credits and pays the commission. Now, since then, both of these companies have moved on. They're both successful companies. I hate to say Don't let yourself become like Zynga, because almost everybody I know in the startup space would be very pleased to end up like Zynga. But Zynga keeps announcing that it's going to get off Facebook. It's going to take its players elsewhere. It's had its ups, it's had its downs. It can't figure out how to do it. Keeps trying, can't figure out how to do it. And there you have the matchup, Facebook versus Zynga. So let's do a bit of analysis here. Okay? Is this a success story or a failure story or just a scary story? Good. Well, it's a great story if you're Facebook. Okay? Facebook owns the platform, and it's always good to own a platform, because anybody else that wants to ride on your platform is operating there at your good graces. Now, Facebook certainly is not the first platform player. Platforms were much in the news in the late 90s during the Microsoft trial, and we'll talk about that in a bit. But Facebook owns the platform. And it was interesting because this was a debate that I had with many friends when Facebook first went public. Conventional wisdom said Facebook doesn't have a revenue model. And my belief, my position, and by way of disclaimer, I bought into Facebook at the IPO and shortly thereafter. And I think then again for a third time when it went way down. My position was Facebook had a great revenue model. Facebook's revenue model was, we run the best party in town. We control the velvet rope, and we've invited 1 billion of our friends to come hang out. You can do whatever you want once you're in the room, as long as we get a cut. The guy controlling the velvet rope does well for himself. And if you have a platform or you control a platform, you might find comparable opportunities. Now, where's the bad? Well, you might be Zynga. In fact, once again, while most of the folks I know at startups wish they could be Zynga, Zynga is just an app developer. It's a very successful, very popular app developer, but it's developing apps that sit on top of Facebook's platform. And they got hit hard. Why? Because a free ride doesn't guarantee a free lunch. Facebook may have opened its doors to let Zynga come in and develop its games and build its clientele. But Zynga learned that everything comes with a cost. And it turns out that Facebook actually played this smart, whether it was intentionally or not. But essentially, a guy making penny ante change isn't worth chasing. It's when a guy becomes big and reliant on you that you actually want to extract this. Zynga might have been able to protect itself preemptively, and we'll talk about ways to do that in a bit. But if you're an app developer, this is a lesson that you might want to bring home. Let's look at how it could have been worse, okay, what we call the potentially ugly. Well, what if Zynga had been publicly held? Why would that have been worse? Oh, I don't know. Publicly held companies that suddenly lose 30% of their revenue do not become Wall Street favorites. As it was, they were contemplating an IPO, they were raising investment capital. This hurt. But if this had been a publicly traded company that got blindsided and lost 30% of its revenue, there would have been hell to pay, not to mention shareholder derivative suits. Which raises an interesting question, and that is, do analysts in the tech space consider the possibility of holdup? Okay? It's not just that Zynga got blindsided. Most players got blindsided. Most of the tech space analysts got blindsided. Nobody saw this coming. I don't recall reading anything 3 months ahead of time that said, yeah, Zynga's generating some pretty good revenues, but they're going to lose a large chunk of it, which makes you wonder about the analysts as well. Now, a couple of quick things before we get to the next question, which is, can they do that? People, I've given this talk before, and people have said that I'm much too hard on Zynga, that they had no way of knowing what was going on, that they were building a startup, they had to focus on the technology, they had to focus on market penetration, there were a whole bunch of other things they had to focus on. And to some extent, that's true. I mean, there are things that are more important. On the other hand, this particular issue was responsible for 30% of their revenue. So when you say, well, they couldn't have been looking everywhere, the question is, how many of the places that they were looking were responsible for more than that? because that's how important this question was. The second thing is, again, I think Zynga is a great company. I have nothing against them. But Zynga got blindsided by something that was completely predictable and completely foreseeable. Things happen. There's business risk out there, and not everything is foreseeable. You can't always see when somebody's going to hit you with a patent litigation suit. You can't see when an earthquake or a hurricane is going to destroy your data center. Some things you can protect yourself against with backups and insurance, but they're just fundamentally not foreseeable. This was foreseeable. This was foreseeable because all you had to do was look at the analysis. It's out there in the economics literature. People talk about it. Now, the other thing is, nobody seems to have learned from this. While I was preparing the slides for this talk a couple of weeks ago, I found something that was floating around the internet. And this was a blog piece about a company called Social Fixer, written by its founder, CEO, a guy named Matt Cruz. Now, don't know Matt Cruz, don't know anything about Social Fixer except what appears in this blog. Don't know if what I read was fiction or gospel, but I suspect it was somewhere in between. There's a lot that I don't know about this. But here's what he reports. He says, I've spent 4 years and countless hours building up a support community around my software. My page had 338,050 likes. My support group had 13,360 members. And my interest list had 1.47 million followers. But all of that work was wiped out in an instant when Facebook decided to shut it down without notice. That, as you might expect, is in bold. And he goes through the travails that he had, not so much because Facebook was trying to get a commission from him, but because in Facebook's opinion, he did something that violated the community standards of Facebook. Anyone who has ever spoken to anyone who's been given one of those notices, it is painfully difficult to figure out what you might have done. And it's even more difficult to get an answer from Facebook. But he goes through all of this and he talks about all of these things that Facebook did and how they were not responsive to his requests. Concludes by saying, I don't know why they did it. I don't quite know how to get back. But you don't worry, because my program is good, my system is good, my client base is good, and I'm going to find another way to communicate with my people that doesn't need Facebook. Now, this was a couple of weeks ago. Maybe he's up and running again. Maybe he isn't. Maybe he's found another way to communicate. If he does, my guess is it'll take him a while to roll out. I don't have anything against him. I don't have anything against Facebook. I don't actually know what happened. What I do know is that I keep finding these stories. Even years after Zynga got blindsided, I keep finding stories about people who are on Facebook or on iPhone or anywhere else that get knocked out of the park, and they don't know why. And they don't know what to do about that. And that's unfortunate, because there are some things that you can do to protect yourself if you're willing to pay attention to some of the strategic questions early on. So let's move on to the question of, well, can they do that? I mean, there are those, as I mentioned, there are those who said that I was too hard on Zynga for not seeing it. There are also those who think I'm being too hard on Facebook, another great company that I like. And by way of full disclosure, as I mentioned, I am an investor in Facebook, so I have no interest in trashing their stock. But they are the platform owner, and certainly in these stories, they are the bigger player. So the question is, can they do that? Well, the answer is maybe. Okay? Let's start with the first one. Of course they can. Well, first of all, we know they can because they did. So that one is easy. But how did they do it? Well, they have many tools at their disposal. Platform owners have patents, they have copyrights, and they have contracts. And those are all legal tools that let them exercise and exert their exclusivity. They also have client bases built into the contracts. Are there defenses? Well, if you've got a platform owner that's got a combination of intellectual property rights and contractual licenses that wants to knock you out of business, do you have any defense? Are there any arguments against it? Well, yes, there are. Yes, there are, because quite frankly, we don't like it when people go ahead and knock their competitors out of commerce using anything other than clear competition. That's what the antitrust laws are about. Every state has an unfair competition law, many if not most of which reach further than the federal antitrust law. And of course there are contractual obligations that go both ways, because you can draft and negotiate and sign licenses and contracts that go in any direction you want. This is what it means to live in the aftermarket, or if you prefer a dramatic flair, the aftermarket life. And let me be very clear here. Most software developers today live in the aftermarket. The entire part of the software industry that is dedicated to building apps or add-ons or anything that sits on someone else's platform lives in the aftermarket, and most of them don't think of themselves that way. Not to mention don't necessarily know what the aftermarket is. Well, okay, fair enough. What are aftermarkets? Let's take a look at some examples. There are classic aftermarkets. This is not something that came up with the internet, and this is certainly not something that came up with software. We can go back and look at some classic aftermarkets. Razor blades. Very early, very successful marketing story written up in all the marketing textbooks, over 100 years old now. It's called Give Away the Razors and Sell the Blades. Okay? We've got a nice little object that we want you to use. It's a nice thing to have. It's a razor blade. We'll give you the blade. We will underprice the blade. Sorry, we will underprice the razor and then sell replacement blades or cartridges. This is still how companies like Gillette make most of their money from shaving systems. They underprice the razors themselves, and they charge a high price for the blades. Probably the most successful example of this strategy that you may or may not know about. Everybody knows Thomas Edison invented the light bulb. Question is, why did Thomas Edison invent the light bulb? What, was he sitting around one day and the light bulb went off and he said, hey, I can invent that? No, Thomas Edison came up with this great idea for generating and distributing power. The problem was, nobody needed power. He needed a killer app. He invented the light bulb as the killer app so that he could make money, as a power company. Has he? Well, all I can say is I'm standing in New York City right now, where the utility company is Consolidated Edison. That's how Edison made his money. Light bulbs were cheap, but he needed people to buy light bulbs and he needed people to buy lamps so that he could sell them. Power. Made light bulbs an aftermarket item. Independent Jaguar mechanics. Why Jaguar? Doesn't really matter. For a long time you needed Jaguar mechanics because the British do a lot of threading in the other direction. But basically you had a lot of guys who made a good living by specializing in one type of car, particularly foreign cars or high-end cars. And what they would do is they would set up their shops and they would be known as specialists in this particular type of vehicle. Well, what happens to an independent Jaguar mechanic when the Jaguar dealership or dealerships in his town go out of business? And the answer is his client base starts to erode very rapidly. His livelihood is entirely dependent on an automaker he doesn't control. Individual coffee servings, we see them all the time. We've got K-cups and various other devices that are now used in offices. Basically the idea is you go out and you buy a machine, and then once you've bought the machine you have to subscribe as an aftermarket purchaser of coffee cups that fit specially in that machine. If you look at them, the machines are really not expensive. The way that the coffee companies make their money is by selling the cups. And interestingly enough, there are a huge number of patents that protect the shape and the means of connections on those cups, because everybody wants to make their money on those cups. And of course, Xerox machine repair, which is up there, not a fundamentally different model, but it turns out to be a particularly interesting one. And we'll talk more about copying machines later on. Contemporary, well, you know, Facebook game developers and iPhone app developers, that's obvious from everything we've talked about. And in the middle, we've got things like replacement toner cartridges and garage doors, also interesting because they showed up in actual lawsuits. Let's look at some strategy. Okay? Basically, how do you protect yourself? Suppose you are an aftermarket player rather than a platform owner. Well, do you want your relationship to be implicit or explicit? And if you want it to be explicit, when's the best time to negotiate? Zynga, from the moment it launched, had a relationship with Facebook. Facebook might not have known or cared. Zynga might not have cared what it was, but it was there because Zynga was reliant on the Facebook platform. Now, how could Zynga have protected itself? Well, suppose that at some point, prior to really becoming a big hit and amassing all this revenue, Zynga had gone to Facebook and said, you know, we've got a nice little sub-community on your platform, and we've got this idea to make money for it, and, you know, we appreciate the work you're doing on the platform, so we want to give you a cut. Oh, Facebook might have asked for the 30% they got eventually, but Zynga wasn't that big yet. And Zynga could easily have said, come on guys, you want a third of our revenue? You're killing us. We can't grow like that. We'll give you 10%. We'll give you 15%. And from day one, Zynga would have been paying Facebook. Would they have negotiated a better deal than 30%? If you look at the time and if you look at where the companies were, I have to believe that they would have. Of course, they would have been paying earlier on. On the other hand, they would have had a guarantee that it was in place. And what's more, they would have given Facebook a vested interest in supporting their needs. One of the other problems is that not only was Zynga at risk for getting this type of for getting hit with this type of commission, Zynga was at risk for Facebook changing the technology in a way that was incompatible with what they were doing. These are very bad risks to undertake. They could have made it explicit, they could have negotiated, they probably could have gotten a better deal had they tried to do it at a different time. In any event, in answer to the latter question, when is the best time to negotiate? There may not be a best time, but I can tell you that the worst time is after you've boasted about how much revenue you have when you are not expecting it. Let's go back and take a look at some legal considerations and see where they come out in any of these areas. IP side tends to favor platform owners. Why? Well, intellectual property is intellectual property within a free market system, which is allegedly what we have on both sides, is designed to carve out little islands of exclusivity. The way that we reward our inventors or our creators is by allowing them to flex their exclusive muscles in ways that we don't allow most other people to do it. And so somebody who has a platform certainly has intellectual property rights buried in that platform. The mix between patents and copyrights and trademarks can differ as you move from one platform to another, but there's almost always something there. And when a platform owner tries to flex his muscles against an app developer or any other aftermarket player, the IP laws are going to tend to favor the platform owners. Not always, but it's weighing down on that side of the scale. Now, the antitrust side works to protect aftermarket players. Of course, most people will tell you antitrust is an ex post protection. It's kind of hard to protect yourself ahead of time with antitrust law, but it does create both a defense and a potential counterattack against IP. Why? Because antitrust is out there to promote competition and to promote competitive markets. That's what it does. And when a platform developer starts flexing muscles against an aftermarket provider, it usually hurts the aftermarket provider's business, at least initially. And there are circumstances, not all but some, there are circumstances under which that leads into an antitrust or an unfair competition violation, or at least an arguable violation that creates a counterclaim or avenue of counterattack. Contracts and licenses. Well, they can play critical roles in implementing all such strategies and in running afoul of their limits, but it's a push because you can negotiate whatever you want, and the trick is to get in at the right time for you and negotiate the best deal for you that you can. Let's take a look at where some of these things have come out in the not too recent past in some of these areas of law. Antitrust. The Microsoft case. I love talking about the Microsoft case. I've written extensively about it. Very, very interesting case from a perspective of antitrust doctrine. Critical case in terms of understanding what's happened to the software industry over the past 15 years. Lots of very rich debates about whether it was a good idea or a bad idea. But basically, what happened in the antitrust case? Sorry, what happened in the Microsoft case? And by the Microsoft case, I'm talking about the large federal case that was launched in 1998 and occupied the front pages for the next couple of years. Well, Microsoft developed Windows, and Windows became the standard platform for PC computers. So by and large, there were some carve-outs. Apple was still out there with its own products. Linux was developing for slightly larger computers, but Microsoft controlled the platform for a very large and very important class of computers with its desktop Windows system. And then something interesting happened. The internet arrived. And the big player in the early days of the internet, the guy who was going to give you the good window into the internet, was Netscape. Netscape was the first major distribution graphical browser. It was a nice piece of software. And everybody thought, aha, this is going to clean Microsoft's clock. And Microsoft had some concerns about it. Bill Gates gave a famous Pearl Harbor Day speech on December 7th of '95, I believe, where he talked about bringing on taking on the internet. And what Microsoft did was they developed a program that shared many of Netscape's nice features called Internet Explorer. And they integrated Internet Explorer into their operating system, Windows 95, so that everybody who bought a computer with Windows 95 automatically got Internet Explorer, had a nice graphical way of connecting to the internet. And then if they also wanted to take the time to go around and find Netscape somewhere and figure out how to download it and install it and do the extra work, they could have a second mechanism that would do it, unless and until Microsoft introduced some complication. And then Microsoft went around and talked to a whole bunch of people who did things like sold computers or sold software and said, we want you to deal only with us and not to deal with Netscape. And so what happened was Microsoft created a very useful platform play. They figured out a way to get their product into the hands of any consumer who might want to contact the internet and make it easy for those consumers to use their product, while simultaneously making hard for those consumers to find and use Netscape. Leveraging platform play. Can they do it? Well, Microsoft certainly had a lot of IP rights at stake. Netscape was kind of out of luck, and Microsoft went ahead and negotiated contracts with big companies that made computers and landed in front of a federal judge with the Department of Justice breathing down their neck. And we started getting some very, very interesting distinctions coming out of the law. For example, it turned out that shortly before Microsoft had done that, they had set up an agreement with the Justice Department. And the agreement said that from now on, and this was in response to some earlier complaints about some of their earlier software, but the agreement said from now on, we agree not to bundle software together, but we reserve the right to integrate new products into our existing software. Well, If there's anybody out there who is certain that they know the difference between software bundled together and software products integrated into a single one, even 15 years after we watched it hashed out in court, they're dancing on some very sharp semantic edges there. The distinction is subtle. But this is what Microsoft did, and Microsoft got in trouble for it. Microsoft spent many years in court, ended up with government oversight, federal oversight, had some restrictions placed on the way that it can put out its projects, got a lot of its dirty laundry aired in public, ended up being attacked similarly in the European Union. And many people believe that it took a long-term psychological effect on Microsoft, and it's one of the reasons that various other software companies have been able to shoot past it, both in terms of creativity and in terms of market capitalization. What's the takeaway? Well, as a strict matter of antitrust laws, platform providers may impose some but not all requirements that eliminate or reduce the scope of their competitors, including those newly competitive firms standing in the way of vertical integration. Clear? Well, it's not supposed to be. It's the law. What it says is that platform providers can do some things that might land them in antitrust trouble, but not everything that they do is going to land them in antitrust trouble. And just because they knock you out of the park doesn't mean that you have a claim. And even if you do have a claim, you probably don't want to go out of business and litigate rather than stay in business and cut a deal. And once you've cut a deal, unless the federal government or perhaps a state attorney general decides to get into the act, the world has moved on from whatever your problems were. Now let's look at the intersection between antitrust and intellectual property. And this is why I like talking about copying machines. We've got Kodak and Xerox. These cases date back to the early 1990s. Xerox, as you may know, was the big player in the copying machines. Kodak was actually a fairly small player in there. Kodak went first. Kodak manufactured copying machines, and they also provided service for their copying machines, and they manufactured replacement parts and manuals. And Kodak went out and sold copying machines to a lot of people. And in much the same way that we had independent Jaguar mechanics, a group of ISOs, or independent service operations, emerged to service Kodak copiers. And what happened would be Kodak customers, people who had Kodak copiers in their offices, would call up one of these ISOs. The ISO would buy the parts from, would order the parts from Kodak and do the work. Well, Kodak decided that they would make more money if they did all the service work themselves. So they changed their rules. And they said, from now on, if you've got a Kodak copier and you need service, you have to call Kodak. We're not selling replacement parts, and we're not providing manuals to any independent service organizations. So your two choices are, you can buy the pieces yourselves and do them in-house. We're very good to our own customers. Or you can call us and we'll do the work for you. And not surprisingly, Kodak frequently charged a higher price point than many of the ISOs. Can they do that? Well, it went to the courts, and the court said, of course. It's Kodak's Aftermarket. Then it went up to the Supreme Court, and the Supreme Court said, not so fast. The Supreme Court said, we're not going to make a decision as to whether or not Kodak can do this, but there's no carte blanche rule out there that says that just because you created an aftermarket, you can leverage your monopoly into it. Maybe this is an antitrust violation. Maybe it isn't. We don't know. We'll send it back to the lower courts. Went back to the lower courts, and the lower courts determined, yes, if in fact a single company aftermarket is a potentially viable antitrust market, Kodak has violated the antitrust laws, and Kodak lost. That was the Ninth Circuit. What happened to Xerox? Same thing. Xerox made copiers. Xerox sold replacement parts, and many of which were patented, and manuals, all of which were copyrighted, and they provided service. And a group of ISOs specialized in servicing Xerox copiers, which was a much bigger market. Xerox decided they'd rather have all the service themselves, so they changed their rules to say, from now on, if you want service, you have to call us. Well, the ISO sued, and it looked like the same case as Kodak. Xerox said, well, you know, we can do this because we're dealing with the sale of patented parts and copyrighted manuals, and we're just trying to protect our IP. This went up to the Federal Circuit, and the Federal Circuit said, yeah, Xerox is right. They're just exerting their intellectual property rights. There's nothing wrong with that. Doesn't really matter if, you know, they're affecting a single-party aftermarket. This is precisely what the patent and copyright laws are there to do. Now, if you listen to the factual descriptions, you might be saying, this is the same case. The only difference, in fact, is that Xerox got away with monopolizing a much larger single-company aftermarket than Kodak did. How is it that Xerox sailed through while Kodak got slapped around? Well, from a legal perspective, there actually is an answer. The answer is Xerox decided early on that this was a patent case. It was front and center in their claim. It went to a pro-patent court, and the court ruled primarily as a matter of intellectual property law. Kodak didn't really build up that angle in their defense. Kodak had a long, a long and very detailed business justification, and somewhere buried in there was a mention of their intellectual property rights. But there wasn't a deep IP analysis, there wasn't a deep patent analysis, none of that. And the court didn't really pay it much attention. They viewed it as part of their business strategy, and therefore they ruled as a matter of antitrust law. So from a legal perspective, there is a way of reconciling these two opinions. In the real world, though, almost everybody believes that this is a circuit split. It's one that the Supreme Court has not resolved. And so if you're sitting back and you're counseling somebody, if you're advising, if you're trying to advise a company sitting either as a Kodak or Xerox or as an ISO, you don't know what the answer is. I mean, you can say, well, if we pitch our defense this way, then it'll take that appellate path and we'll have better odds. That's really, if you're in litigation already, that's fine advice. Probably not good advice to give at the strategic level. The takeaway is leveraging your IP rights and or other assets to reduce competition in your own single provider aftermarket may be acceptable, or it may violate the antitrust laws, or maybe there's a circuit split. So for those of us in the advising game, good luck. How about copyright? Do we have a similar thing in copyright? Well, it turns out that in 1998, we passed a law called the Digital Millennium Copyright Act, which was designed in part to bring copyright into the 21st century. The DMCA, as it's known, introduced a fundamentally new provision to the copyright law, something that had never been there before, called the anti-circumvention provisions. And the anti-circumvention provisions made it illegal to market a device, or actually made it illegal to circumvent a technological measure put in place to control access to a copyrighted work. Did you follow all that? Well, if you followed it the first time, you wanted a few. What does that mean? Well, I've got a copyrighted work. I don't want anybody accessing it. So what I'm going to do is I'm going to use technology to hide it. What type of technology? Oh, I don't know, maybe encryption technology. I'm going to take my copyrighted work and I'm going to encrypt it. And the only people I'm going to allow to encrypt it are authorized users, people who pay me for a password. Or maybe I won't authorize any users and I'll be the only one who can access it. Why might I want to do that? Well, early on, we saw some very interesting things that happened. The first couple of cases dealt with precisely what Congress had in mind when they passed this law. Had in mind videos. What happened in the video world? Well, movie studios decided they wanted to start selling their movies on DVDs. So they did. But they also wanted to make sure they didn't get hit with Napster-like problems and the rampant copying that the record companies had gotten. So they encrypted it. They encrypted it using an encryption system called CSS, or a content scrambling system. And they sold keys to the content scrambling system to anybody, to Apple and to anyone who manufactured a PC. And now anybody who had one of those computers could go out, buy a DVD, and play it back on their machine. And that was fine. This was before anybody had the bandwidth to really think about streaming very quickly. Problem was, and here's a red flag, okay? If you're running a Linux box, you were out of luck. Now, who was running Linux boxes in the late 90s? Hackers. So what we've done is we've taken the world of the top software developers, people really interested in coming up with clever ways around technology, and we've said to them, if you want to watch the DVD that you just purchased at Blockbuster on your computer, you have to find a way around the encryption scheme. Well, maybe that wasn't the smartest thing to announce, but that was what the movie studios announced. So they found a way around it. They came up with a program called DCSS, went all the way to the courts, and the court said this is precisely what the anti-circumvention provision is talking about. You can't do it. All right, what does that have to do with aftermarkets? Aha, people got smart. And people said, you know what? That shouldn't apply just to DVDs. That should apply to all software, because all software is protected by copyright. And so you got a couple of companies that manufactured products with chips, and the chips contained embedded software. First two cases that came out, and they were filed in the same month, dealt with Lexmark printers and the replacement toner cartridges, and closer to my heart, because I got to work on this one, garage door openers and clickers for garage door openers. Chamberlain, it turns out, is the 800-pound gorilla of the garage door opener world, and they manufactured systems that anyone who has a garage has probably seen. You've got a base unit that's got a receiver in it that's in your garage that gets signals from the clicker in your car, receives them, tells the garage door to open, powers the mechanics, runs it there. Well, Chamberlain decided that what they were going to do is they were going to encrypt the embedded software. So they did. A company called Skylink manufactured programmable universal remotes. And they said, well, we can interact with the Chamberlain base unit, and you can open your Chamberlain door as well as you can anything else. Chamberlain said, aha, we have decrypted our software. By the way, it turns out it was not a very good encryption algorithm. You read the case, you can find out what it was. But it was an encryption algorithm. And as Chamberlain said, the only way that you could have communicated, the only way that your programmable clicker could have communicated with our base unit is if you decrypted the software, which means you circumvented a technological measure designed to control access to our copyrighted embedded software, therefore violated the anti-circumvention provision. Now, why would this matter? Well, if this were true, if Chamberlain's argument prevailed, and Lexmark made the corresponding argument, if Chamberlain's argument prevailed, then anybody who manufactured any product that involved a base unit and a potential add-on could do the same thing. And that means that we would have completely eliminated the notion of competitive aftermarkets, because anybody who had a base unit could monopolize the aftermarket at will. And this is not just a matter of software, mind you. We're talking about products that contain chips with embedded software, which is increasingly everything. Went up to the courts. The Sixth Circuit in Lexmark and the Federal Circuit in Chamberlain both said there are flaws in that reasoning. They found different flaws in the reasoning. They're very technical. They're very interesting. But they both said you can't use anti-circumvention to violate the antitrust laws in this way, and they preserved the notion of competitive, or at least potentially competitive, single-player aftermarkets. Now, what happened in MDY? Well, this involves a product called World of Warcraft. And somebody who came along and invented a bot that went into the World of Warcraft, and you had exactly the same argument that came up. Okay? You had exactly the same argument that came up. The makers of World of Warcraft said, screw this, we don't want your bot in there. Guys said you can't do anything about it. They got into a big fight, went up to the Ninth Circuit. Ninth Circuit went through Chamberlain with a fine-tooth comb explained why it disagreed with everything in the Chamberlain opinion, and said World of Warcraft can put up no bot signs, no problems. So the Ninth Circuit has eliminated the reasoning that protected competitive aftermarkets and put in place an environment in which if you control a platform, you can leverage yourself in a lot of ways that would, under normal circumstances, be considered anti-competitive. So what's the takeaway? Well, as a matter of copyright law, it's acceptable for at least some platform providers to exclude aftermarket competition using simple encryption algorithms. That's the takeaway. It's unclear how widespread this authority is, because there's a circuit split, and whether it extends to hardware devices using embedded software. We just don't know. Now, you may note that after the Xerox and Kodak debacle, I said that everybody believes that there's a circuit split. There's really no doubting that there's a circuit split between Chamberlain and MDY, because the Ninth Circuit, as I mentioned, took many, many pages that were completely unnecessary in its ruling to explain why it disagreed with every aspect of the Federal Circuit's ruling in Chamberlain. So there's really no way to reconcile these opinions. Now, they talked about slightly different environments, so maybe you can get away with that, but we just don't know. We just don't know what's going on here. How about contracts on terms of use? Well, these are things people leverage all the time. Very early on, eBay posted no bots allowed because it didn't want shopping bots on its site. No pornography. Well, that's fairly common. Limitations on revenue, commissions. If I control a platform, I want the commission. That's pretty much where we came in. But there are all sorts of things that platform owners can put into their contracts. And this is critical. A lot of people miss this. Contracts and licenses are mechanisms for implementing business strategy. They can cut in many ways, and they represent the best forum for negotiating those strategies. What do I mean by that? All right, and this is really the point that people miss. A lot of people out there, particularly in the technology world, who hire a legal team to draft their licenses, and they hire a strategy team or a marketing team to develop their business models, describe the business models to investors. Your contracts and your licenses, if you're in that type of environment, your contracts and licenses are your business model, because those are the things that determine who pays you, under what sets of circumstances, how much you get paid, who you pay under what sets of circumstances, and what your cost structure is. The strategy team's business plan, the one you told investors, that's aspirational. The real one is the one that's embedded in your contracts and licenses. And if you want to get those right, you should pay more attention to them. Let's talk about strategy very quickly. How does one navigate the aftermarket? Well, we've talked about most of these things along the way. We talked about giving away razors and selling blades. It's an old strategy, works today. Anticipate. Well, that's usually good advice. Again, I keep going back to the Facebook Zynga story, because the bottom line is you should never be blindsided by something predictable. Pay attention to your environment. Think about what's going on. Negotiating early versus negotiating late. Well, you want to negotiate on the way up when you still have some leverage. Once you've made it and you're completely reliant on somebody else, they're not in a good position to do that. And also, study markets and statements, pay attention to what's going on. And I emphasize that as far as I can tell, Facebook's move against Zynga caught not only Zynga by surprise, but most, if not all, market analysts. Somebody wasn't paying attention, and there were a lot of somebodies. Now we can look for cues to try to understand what the platform's model is. Okay? Are there existing competitors? Are there existing aftermarkets? SDKs. Okay? SDKs are phenomenal tip-offs. If I want there to be a competitive aftermarket, I'm putting out a software developer kit because I want app developers to come along. Now, if I'm the platform provider and I'm putting out an SDK, I've got contracts and licenses associated with that. I may reserve some rights to myself, But I've fundamentally given away some rights as well. Otherwise, I'd have some very foolish software developers relying on my continued goodwill. And look at the relationships that exist between the platform provider and other aftermarket players. I can rag on I can rag on platform players who pull strategic coups that help them at the expense of their aftermarket developers. But the bottom line is that there are plenty of healthy relationships out there between platform developers and aftermarket players. Platform developers want there to be aftermarket players. In Apple's first life, back in the 80s, it policed everybody that was doing anything connected to its Macintoshes. And it wrote all the software and developed everything, and all the app developers went over to Microsoft, and Microsoft did a lot better. Microsoft invited developers. Apple today wants you to write iPhone apps. If you have a clever idea that'll run well on a smartphone, you better bet that Apple wants you developing it. Apple has figured out how to come up with very healthy aftermarket relationships. Google has done it with Android. Facebook has done it to some extent. There's a constellation in here, and the platform provider is the central player. But he's not the only player. And you should be able to make a lot of money and develop a good business and have a healthy relationship between platform developers and app developers or aftermarket players. Trade secrets, another good way of protecting yourself, protecting your own IP. Well, you know, IP cuts both ways. And much as Facebook has IP, so does Zynga. And to the extent that Facebook wants to make any money from Zynga, Facebook's going to have to cut Zynga some slack with its own IP rights. And of course, understanding contracts and licenses. This is the key that I spoke about moments ago when I said that your contracts and licenses really are your business model. More. Strategic negotiations, can't emphasize this enough. You got to pick the timing and you got to pick what you want. And you have to be reasonable. Zynga could have, I believe, Zynga could have paid a smaller commission had they been willing to pay a commission earlier on. This is how we get to partnering and preferred relationships. And of course, recognizing the asymmetry in the relationships. I would never tell anybody not to enter an aftermarket. Aftermarkets are great businesses, and increasingly, they're where most of our technology players are making their money. But you have to realize that no matter how big you are as an aftermarket player, you're not the biggest guy. You're part of a constellation, and the biggest player in the constellation is the platform provider. There is an asymmetry in your relationship that can be hugely beneficial and mutually profitable if you nurture it. But like most relationships, will fall apart badly if you fail to nurture it and fail to pay attention to it. And guess who's more likely to get burned? Well, it ain't the bigger guy. Let's talk about how many grains of salt should one apply. Why? Because quite frankly, everybody's got something to sell, and I believe that when I tell you this stuff or anybody else tells you anything, you should try to figure out where we're coming from. So here's who I am and here's where I'm coming from. I'm a partner at the firm of Ramon PC. We have very fine corporate transactional and litigation services. We tend to specialize. We do a lot of work for startups, tech companies, small to mid-sized clients. We work with our clients to develop value-based pricing. From my own perspective, I started out with a PhD in computer science from Columbia. I was later a professor at USC. I picked up a JD at Georgetown and became a lawyer. And I used that to serve as a law clerk to the Federal Circuit, which is one of the reasons I have a particular affinity for the Chamberlain case. I was one of the clerks involved in drafting that. I'm also a registered patent attorney. So I have done some drafting of patents myself. And in between my careers as a computer scientist and my career as a lawyer, I served as an economic consultant primarily for Charles River Associates. I did a lot of antitrust analysis and litigation. Right now, I've got a strategic practice where I work with clients on issues like the ones that we talked about today. I help them leverage their ideas and their intellectual property into business plans. Basically, the question is, how do you turn an idea into an asset and an asset into money? I have a transactional practice where I do some IP valuation. I do some license drafting. I do a little bit of patent drafting. And I've got a litigation practice where I serve much more often as an expert witness than as counsel. And I do damages work because I've done valuation. I do technology work because I've done technology, and I do industry practice because I've spent a lot of time studying strategy. I also publish occasionally, not as much as I'd like to these days, but I've got a couple of books out. My current research interests focus on the interface between intellectual property and antitrust. My past books, one is called Digital Phoenix, one is called The Secret Circuit. They both deal with different aspects of the interplay among new technologies, the businesses that exploit them to make money, the laws that govern those industries, and the public policies that should guide the development of legal reform. So that's a bit about me, and here is how you contact me. And I've left myself a couple of minutes at the end just because, as I promised, this talk is part of a series. The general questions that interest me today deal with the strategic maneuvering in a strong IP era. For better or for worse, intellectual property has gone through ups and downs over the past century. There have been periods where the courts and the government in general frowned upon IP, and there have been periods in which IP was viewed very favorably. Right now, we're in a time that IP is viewed very favorably. Now, I've written a lot of articles, and I've written in my books, talk about ways that I think we could improve the IP system. I've written about patents, I've written about copyrights, I've written about antitrust, because I'm in favor of robust economic growth. And employed correctly, intellectual property rights are good ways of fostering robust economic growth. But they can be abused. And right now, we are in an era of strong intellectual property. You read about it all the time. People are up in arms about copyright law becoming more draconian. They're up in arms about patent law. They're up in arms about patent trolls or non-practicing entities. There has actually been a fair amount of legislative work in both the copyright and the patent realm. The Supreme Court has been hearing more of these cases, and it's not surprising because this is what governs our industry. From a public policy perspective, I'm perfectly happy to talk about ways that we can make the system better. But the bottom line is that doesn't help my clients. My clients, and I'd like to think somebody listening to this would like to become a client, need to understand how they navigate the terrain. Okay? It doesn't really matter whether today's patent laws are wonderful or horrible, whether today's copyright laws are properly promoting creativity or not. If you've got a business, your question is, how do you work within the existing environment? And these are the issues that really interest me, and this is why I like talking about aftermarkets. Aftermarkets are critical. They play a critical role in all of our major technology industries. Everything these days is about platforms. It's about app development. This is where people are working. This is where there's growth in the economy. In fact, this is one of the few areas where there's robust growth in the economy. And the bottom line is the big companies like Facebook and Google and Microsoft and Apple have done us all a huge favor by creating platforms on which multiple companies can grow. And all of those companies are aftermarket players, and all of those companies have relationships with the platform developers. And even the platform developers, by the way, have relationships among themselves. Some of you may have tuned into a debate over net neutrality, which asks the question of, can big bandwidth providers negotiate special deals for themselves? Well, guess what? The biggest bandwidth user of them all is Netflix. And Netflix becomes an aftermarket riding on the cable platform that the major cable companies provide. This is why I think that winning the aftermarket is a good topic with which to launch an inquiry into strategic navigation of a strong IP era. I hope that much of this material has been interesting to you. Those of you who'd like to contact me, I've kept my contact information up here long enough for you to jot it down. I'd be pleased to field questions. I'd be pleased to talk to you. And if you're looking for someone to help you navigate some of these strategic straits, please do think of me. And in the meantime, I think I've run through my hour, and so I am going to call it a day. Thank you very much.